Good morning to all of you. We are going to study regarding cancellation of bail. Normally, it is the discretion of the court to give bail in a non-bailable offence, maybe under section 437, 438, or if he is in custody, 439 CRPC. So we have to remember the great jurist, late Justice V.R. Krishnaiyer, who said, bail is a right and jail is an exception. But of course, granting bail is the personal discretion of the justice. Right. About 3 weeks back, I have made a video on the column Bhayya is back. A banner which displayed that Bhayya, a rape case accused, he was coming out on bail. Therefore, the banners were the Flexis, they were shown, they have erupted in the city in Madhya Pradesh with the heading that Bhayya is back. Please look to my video number 1647 with the heading Bhayya is back. Right? But actually, in this case, please remember, this Bhayya is a law student, 5 years law student, youth leader, and so many qualifications are there. A rich political influential family background is there. Anyway, he has actually falsely promised a woman that he would get her, that he would marry her, enjoyed her for 3 years or so, ultimately left her to her fate, where she filed a case of 376 clause 2 clause N of the Indian Penal Code, and 506 also because he threatened her. So this incident has become a sensational in Madhya Pradesh. Right. So he was arrested, he was put in jail. Of course, he was released after 45 days or so, he was released on bail. But the real problem started here. So the victim, so you can read the case as Mrs. P versus State of Madhya Pradesh. So previously, same case I have discussed in my video number 1647. If you see that video, entire facts will come to light. Here the main point is, while hearing, yes, she filed a bail cancellation petition for the bail granted to our Bhayya. Already CJI bench, CJI Sri N.V. Ramana, Justice Madam Hema Kohli and Krishna Mirari, who were hearing the case at that particular point of time, CJI cautioned the advocate, let your Bhayya be careful. So did he do any great work? Is he coming from America? So a person who is returning from jail, can he do that? So let him be careful, it's not proper. At the time itself he cautioned. But anyway, yesterday the judgment has been pronounced in this bail petition, and the bail granted to the accuser or Mr. Bhayya is cancelled. He has to surrender within a week. Why this happened? This is important for us to know. So the Supreme Court observed that brazen conduct on the part of the appellant, brazen conduct on the part of the accused person evoked a bona fide fear, not expectation. It is a bona fide fear in the mind of the plaintiff or in the mind of the victim that she would not get a free and fair trial. Please remember, Article 21, what does it say? Free and fair trial. She has got a bona fide doubt that she may not get the so-called fair trial within the possible time, because he has come out on bail, and while coming out on bail, he made a big show as though he is coming back. Right. Please remember, if he is on bail, he may influence the witnesses also because of his position. Already I told you, he was an influential, rich political family, student of law student union, students union leader. So if such people behave like this, they do not deserve the concession of bail. So he is directed to surrender within 1 week. So please remember. And how this has, now you have to hear the defense also. The defense stated, Your Honor, the celebration of Ma Narmada Jayanti, at that time, the Flexis have erupted, stating that since he is coming, they said that Bhayya is back. Actually, it is a celebration. It is a Flexi erected on the eve of celebration of a festival of Narmada Jayanti. But the court observed the taglines, hashtags used for the used by the followers, and the crown, which emoji of crown, all these things, and heart tagged to this social media platform. Definitely the captions and portraying him as a hero, they say that he is very influential fellow. He wanted to take chance of the occasion. Definitely there is a chance of his tampering with evidence or influencing the witnesses. So it cannot be, the defense cannot be actually accepted. That is what Supreme Court held. So please remember, even though he was arrested on 29/9/2021 and released within 40 days, his fate is not good. He has to go back once again to the jail and he has to suffer till the trial is over. I think he may not be released. Of course, we can't say, because the bail is the personal discretion of the judge. But anyway, the lesson your clients have to draw from this type is, please, even though your client comes out with a clean acquittal, even though your client gets bail application, you should not make it a show. No pomper, no fanfare, no hullabulla. If that happens, there is a chance that your bail petition may be cancelled, and once again your client may have to go to gallows. This is the lesson which you have to draw. Thank you very much.